Judge Sierra Jones presiding. Please be seated.
Mr. Brown, can you approach? All right. So now where are you here?
I'm here for Mr. Bunker. That would be page 22.
Let's go to page 22. C 390495, State of Nevada versus Jackson Bunker. Make the record reflect that Mr. Bunker is present in custody. Mr. Pinnell is here on his behalf. Mr. Pesci is here on behalf of the state. This is daytime set for the defendant's motion to continue the trial. That's set for January 20th. As well as counsel call. Mr. Pesci, have you seen the motion?
Yes, Your Honor.
What is the state's position?
We submit this.
All right. The motion, Mr. Bunker, sir, you understand what's happening?
Oh, yeah.
Is that a yes?
Yes, ma'am.
All right. All right. I'm gonna grant the motion to continue. The jury trial is gonna be vacated. Did you guys discuss when you wanted this reset?
Yes, Your Honor. My client has consented to continuing it. He has some reservations about how long it might take, but I think based on Mr. Pesci's schedule and my own, September looks best.
Okay. Mr. Pesci, anything else you want to add?
Yes, there was some conversations about June. Unfortunately, I have three, not unfortunately, but I have three set in front of you in June, so I don't think I could pull that off.
Oh, I guess I'm not going on vacation in June, Mr. Pesci.
I didn't set those two.
All right. Let's go ahead and let's set the jury trial for September 14th.
Your trial is going to be September 3rd at 9 a.m. Your pre-trial conference is going to be August 27th at 9 a.m. And your status check trial readiness will be April 9th at 9 a.m.
Thank you, Judge.
Thank you, Your Honor.
Guys. Is that all you have, Mr. Valente?
That's right, yes.
Okay. Mr. Valente, what are you here on?
I'm on page 14, Vasquez Machado.
Okay. Let's go to page 14, C 389906, State of Nevada versus Julio Vasquez. May the record reflect that Mr. Vasquez is present in custody. Mr. Valente is here on his behalf. Ms. Mercer is here on behalf of the state. This is a daytime set for status check trial readiness. Mr. Valente, how are you doing for June 8th?
Well, I mean, I still don't have the officer's report as well as a coroner's report, which was the basis for the continuance the last time.
If memory serves me correctly, I believe the coroner's report is done. I thought I sent it to Mr. Valente, but I'm going to call my office when I return. The officer's report, the detective indicated she's still working on.
Okay, can you reach out to the detective and let me know that that clock is ticking?
Yes.
And let me know about the coroner's report.
Yes, ma'am.
All right, so I'm going to have a status check at 30 just to make sure those things have been handed over. That date is?
February 5th at 9 a.m.
Thank you, Your Honor.
All right, thank you guys. All right. Mr. Martinez, what are you here on?
Your Honor, I'm here on page 6. I don't know if we have all the attorneys for the co-defendant.
I don't think we do. As soon as we do, I'll...
We have Mr. Sheets.
Mr. Sheets, I thought I saw Mr. Flayhide.
It's right back here, Your Honor.
Okay, are you ready? And who else do we need?
Maybe yes.
I know the DA is here.
Well, Mr. Martinez is here. Mr. Sheets, Mr. Flayhide. There was somebody else that was there. Mr. Adris. We need Paul Adris, so as soon as he gets here, I'll call you back.
Great, thank you, Judge.
All right, let's go to page 1. C 395678, State of Nevada versus Darnell Davis. May the record, Ms. Shamley, may the record reflect Mr. Davis is present in custody. Ms. Shamley is here on his behalf. Anybody from the state of Nevada? Mr. DeJacon is here on behalf of the state. This is daytime set for the defendant's motion to dismiss counsel. Mr. Davis, is it your desire to continue forward with that motion?
Yes, please.
All right, I'm going to set this down for a young hearing. Monday morning, January 12th at 8:30. Okay?
I apologize, Judge, what is the defendant's name?
Darnell David.
It's Mr. Henry's case.
Cameron?
That's all we really. All right, Mr. I don't think he's there. The seat is empty, Mr. Yu.
Your Honor, he just called me from his jail cell.
Oh, I love
They
this
haven't
for us.
transported him.
Hold on just 1 second. Let me just call it so we can go over that. All right, let's go to page 19. C 250528, State of Nevada versus Julius Bradford. For all may the record reflect Mr. Bradford is not present. May the record reflect the prison appears to be online, but the chair is empty. Mr. Bradford is pro se. Mr. Ewing is here as standby counsel. Mr. Pesci is here on behalf of the state, and Ms. Corey is here on behalf of the Nevada Department of Corrections from the Attorney General's office. Mr. Ewing.
You know, I got a call 5 minutes ago from him. He hasn't been transported. Doesn't know why. It usually takes like an hour to get them anywhere
Right.
over there.
Ms. Corey, do you have any representations about why he hasn't been transported to the video room?
I have not, Your Honor. I haven't heard from them this morning. I can try giving them another call.
Okay, can you call them so that you can give us an update as to whether or not they're going to get him to the video room?
I will do that right now. Thank you.
Okay, so Mr. Young, you can just hang out and I'll come back to you guys as soon as she comes back. All right, Ms. Lowe, are you ready?
Yes, Your Honor.
All right, let's go to page 16, A873070, Michael Rodriguez versus the State of Nevada. Make the record reflect Mr. Rodriguez is not present. He's the custody of the Nevada Department of Corrections. Ms. Lowe is here on his behalf. Mr. Pesci is here on behalf of the state. This is the time set for further proceedings from the Supreme Court, so we need to set this down for an evidentiary hearing in regards to claims 1 and 4, based upon the Supreme Court order. Have you guys had a discussion about when you wanted the hearing?
No,
No, we didn't. I didn't know who would be assigned to it.
it's not going to be me.
It's not going to be you, Mr. Pesci?
Sorry.
All right, well, I'm going to go ahead and set the hearing, and Mr. Pesci, you guys are going to need to figure out who this case is assigned to.
It's Mr. Ports, because he took over this record.
Okay. All right, so we're going to need to go ahead and set it down for a hearing. Can you guys be ready on January 30th?
Anyway, let me, one moment, please. Yeah, I do clear that date, but I just wanted to note that Michael Rodriguez has expressed the preference of being able to appear via video for the upcoming hearings. They said I would ask. But yes, the 30th for the actual evidentiary hearing or for another status?
No, for the evidentiary hearing.
Okay, yeah, that should work for me. I guess I'm a little bit, well, no, it should be all right for the witnesses too.
All right, well, we're going to set it, and then if you guys get notification from the witnesses that they're not available, then you guys can contact Chambers and we can reset the date.
All right.
And so, does he want to appear via video for the hearing?
He did request, right, that he be allowed to appear. He's from Lovelock and he's involved in programming and says every time he's yanked out, he has to start over or misses things. So, yes, he did want to stay even for the, I said, well, you're going to be testifying. I don't know if she'll allow that, but I'll ask.
How's he going to confer with his attorney?
If he's okay with not conferring with his attorney, Mr. Pesci.
Okay.
So you're okay with him not being in the same room as you because you're not going to be able to talk to him?
Right, that is a concern. So I'll discuss that with him. I guess.
Well, the problem with that, Ms. Lowe, is if you want him to appear via video, even if you want him here, the order to transport needs to be done today because the prison requires 3 weeks. So I need the order to transport today in regards to whether he's going to be here or be on video.
I did have misgivings on that, so let's transport him.
All right. Well, I need you to submit the order today.
I do the order? Does the state usually do that?
No, not on these. You can do it.
Okay.
All right. Submit it today.
All right.
All right. Thank you, guys.
Thank you. Is that it?
Yeah, that's it. Mr. Rahman, have you had any contact with Ms. Hashmati or somebody from the public defender's office?
Your Honor, it's Ms. Hawkins. She'll be here around 9:50.
Mr. Gaston, are you ready?
Sure. Mr. Sanchez, Ricky Sanchez.
Okay. Let's go to page 8. Oh, that's the sentencing, right?
Yeah.
Yeah, I'm not sure of that.
Okay, that's fine.
All right. Who's here on Watson? Are you ready?
Yes.
All right, let's go to page 18, C395960, State of Nevada versus Lewis Watson. May the record reflect Mr. Watson is present in custody. Ms. Oliver is here on his behalf. Mr. Pesci is here on behalf of the state. This is the date and time set for our status check trial readiness. Ms. Oliver, are you on track for February 9th?
Your Honor, sure. Mr. Pesci is probably one of the best at getting discovery, so I believe fully that
Mr. Zach, did you hear that, what she said?
He gets it very, very early, and it's very thorough. I forgot to check before I came. Did we have the officer's report yet, or no?
I don't believe so.
So there are still things, obviously they're outstanding just because of the nature of the case.
Right.
We're continuing to try to investigate some things that Mr. Watson has pointed out to us. So I can do what I can do.
Right.
So far, so good. But Mr. Watson wants us to go trial.
I get it, all right? So right now, I'm going to leave the dates as they are, and I'll see you guys back here for your pre-trial on the 22nd.
Thank you.
Okay? Is somebody here from Mr. Becker's office? Mr. Patrick, you ready?
Yes, ma'am.
Let's go to page 21, C385494-4, State of Nevada versus William Hill. May the record reflect that Mr. Hill is present in custody. Mr. Patrick is here on his behalf. Mr. Palal is here on behalf of the state. This is on for the state's motion as well as the statute EMP. What happened to the new case?
So, Judge, the new case was dismissed as expected on Tuesday. I'm sure the court read the police report. Mr. Palal read the police report. Chatting with Mr. Palal yesterday, I'm going to ask that Mr. Hill be released today on the original bond and house arrest, and I believe Mr. Palal is going to have no objection.
I would say that if you read the police report, you would also realize that the defendant admitted to having an extra phone that he was hiding from the house arrest officer, which I think is probably less than the behavior one would expect for somebody who got a $100,000 bail on a murder that's on video. So that I would suggest that maybe a little less glibness would be appropriate given the circumstances here. That being said, I will submit to the court regarding the defendant's custodial status.
Okay. All right, so Mr. Hill, you understand the concerns based on what Mr. Palal stated. You're not allowed to hide phones from the house arrest officer. Do you understand that?
Yes, ma'am.
All right, you understand this court doesn't tolerate new cases under any circumstances. So I'm going to reinstate your original release conditions because that new case was dismissed. All right, so today you're going to be released back on house arrest with the previous bond already having been posted.
Thank you, Your Honor.
Thank you. All right, is anybody here on the fields?
That's my case. It's with Mr. O'Brien.
Okay. Ms. Stanley, can you find out where Mr. O'Brien is?
Okay.
From our office, Joe?
Yes.
Yeah, he's actually out sick today. I just got a text from him.
Okay.
So I'll figure out what's going on.
Okay. Mr. Helmick, you ready?
Yes, ma'am.
Let's go to page 2, C395950, State of Nevada versus Tyler Johns. May the record reflect that Mr. Johns is present in custody. Mr. Helmick is here on his behalf. Mr. DeJackalo is here on behalf of the state. This is the day and time set for continued arraignment. State, I do not see a notice filed as of this morning. Is this?
We are not taking that.
Okay, in light of that, Mr. Helmick, are you prepared to go forward with the arraignment?
Yeah.
All right, Mr. Johns, sir, what is your full name?
Tyler Matthew Johns,
How old are you?
22 years old.
How far did you go in school?
High school now.
Do you read, write, and understand the English language?
Yes, ma'am.
Sir, are you currently under the influence of any drugs, medication, or alcoholic beverages at this time?
No, Your Honor.
Do you understand the proceedings that are happening here today?
Yes, Your Honor.
Sir, are you familiar with the 3 charges that you're facing?
Yes, Your Honor.
Do you understand those charges?
Yes, Your Honor.
As to those charges, how do you plead? Guilty or not guilty?
Not guilty, Your Honor.
Sir, you have the right to have a jury trial set within 60 days. Would you like to invoke or waive that right?
I'd like to waive that right, Your Honor.
Okay. This case is going to be assigned to Department 6. This case is going to have a status check trial setting in Department 6. That date is?
January 13th at 9:30.
Okay, thank you, Your Honor.
All right, thank you guys.
Thank you, Your Honor.
So we're still waiting for Mr. Ages.
Ken Cozell is going to be here for him, Your Honor.
Oh, yes. Can one of you reach out to him and find out where he is? Mr. Dustin, can you approach on another way now?
Yes, ma'am.
From the prison.
Yes, Your Honor, thank you. I just got off the phone with the institution. Mr. Bradford refused his transport up to operations to attend this court hearing today. They are getting him to sign a document stating as such, and if he refuses, I will have a declaration from the search and escort team about his refusal.
Okay, I get that. So we're back on the record at C250928. So based upon those representations, what I'm going to do is I'm going to set this down in a status check in 60 days. If you could submit those documents to the court, and if they have documentation that he refused transport to the hearing today, the court is going to rule on the pleadings and just issue a written decision.
Yes, Your Honor, I will get that submitted as soon as possible.
Okay.
March 12th at 9 a.m.
Thanks, Judge.
Thank you.
Thank you.
Thank you, Mr. Newman.
Your Honor?
Yes. Just 1 second.
No rush.
Let's go on pages 3, 4, 5, and 6. C396273-1, State Matter versus Charnay Hopkins. May the record reflect that Ms. Hopkins is present in custody. Mr. Fayad is here on her behalf. State Matter versus Devyn Jackson. May the record reflect that Mr. Jackson is present in custody. Mr. Kozol is here on behalf of Mr. Adris. State of Nevada versus Dora Williams. May the record reflect that Ms. Williams is present in custody. Mr. Sheets is here on her behalf. State of Nevada versus Dwight Delancey. May the record reflect that Mr. Delancey is present in custody. Mr. Martinez is here on his behalf. Mr. DiGiacomo and Ms. Anderson are here on behalf of the state. This is the date and time set for arraignment. Are you guys prepared to go forward with the arraignment?
Yes, Your Honor. Yes, Your Honor.
Yes, Your Honor. All right, we're going to take them in order, so let's start with you, Ms. Hopkins. Ma'am, what is your full name?
Charnay Cheryl Hopkins.
How old are you?
33.
How far did you go to school?
Some college.
Do you read, write, and understand the English language?
Yes, ma'am.
Ma'am, are you currently under the influence of any drugs, medication, or alcoholic beverages at this time?
No, ma'am.
Do you understand the proceedings that are happening here today?
Yes, ma'am.
Ma'am, are you familiar with the 2 charges that you're facing?
Yes, ma'am.
Do you understand those charges?
Yes, ma'am.
As to those charges, how do you plead? Guilty or not guilty?
Not guilty.
Ma'am, you have the right to have a jury trial set within 60 days. Would you like to invoke or waive that right?
She would like to invoke, Your Honor.
Okay. All right, let's go to Mr. Jackson. Mr. Jackson, sir, what is your full name?
Devyn Michaels,
How old are you?
37.
How far did you go to school?
I didn't get past the start, but I was first grade, sixth grade. Sixth grade.
Sixth grade. Do you read, write, and understand the English language?
A little, yes.
Somewhat. Is that a yes?
Yes.
Sir, are you currently under the influence of any drugs, medication, or alcoholic beverages at this time?
Medication.
Does that medication in any way affect your ability to understand the proceedings that are happening here today?
No.
You understand the proceedings that are happening here today?
Yes, ma'am.
Sir, are you familiar with the 2 charges that you're facing?
Yes, ma'am.
Do you understand those charges?
Yes.
As to those charges, how do you plead? Guilty or not guilty?
Not guilty.
Sir, you have the right to have a jury trial set within 60 days. Would you like to invoke or waive that right?
I'm going to invoke.
Okay. All right, let's go to Ms. Williams. Ms. Williams, ma'am? What is your full name?
George Siobhan Williams,
How old are you?
33,
How far did you go to school?
junior high school.
Okay. Do you read, write, and understand the English language?
Yes.
Ma'am, are you currently under the influence of any drugs, medication, or alcoholic beverages at this time? Do you understand the proceedings that are happening here today?
Yes, ma'am.
Ma'am, are you familiar with the 2 charges that you're facing?
Yes.
Do you understand those charges?
Yes.
As to those charges, how do you plead? Guilty or not guilty?
Not guilty.
Ma'am, you have the right to have a jury trial set within 60 days. Would you like to invoke or waive that right?
Invoke.
Okay. All right, let's go to Mr. Delancey, sir. Sir, what is your full name? How old are you?
27.
How far did you go in school?
High school.
Do you read, write, and understand the English language?
Yes, ma'am.
Sir, are you currently under the influence of any drugs, medication, or alcoholic beverages at this time?
No, ma'am.
Do you understand the proceedings that are happening here today?
Yes, ma'am.
Sir, are you familiar with the 2 charges that you're facing?
Yes, ma'am.
Do you understand those charges?
I do.
As to those charges, how do you plead? Guilty or not guilty?
Not guilty.
Sir, you have the right to have a jury trial set within 60 days. Would you like to invoke or waive that right?
Please.
Okay. This case is going to be assigned to Department 12. This case is going to have a status check trial setting in Department 12. That date is?
It's going to be January 15th at 8:30.
All right?
Judge, can I have you call Mr. Rouse?
Thank you, Your Honor.
Yes.
And
12.
co-defendant, Ms. Lopez.
All right, let's go to page 12 and 13. C, 388436, State of Nevada versus Daniel Roush. State of Nevada versus Gina Lopez. May the record reflect that Mr. Roush is present in custody. Mr. Horvath's here on his behalf. May the record reflect Ms. Lopez is present in custody. Ms. McNeil is not present. Mr. DiGiacomo is here on behalf of the state. Mr. DiGiacomo?
Yes, Ms. McNeil reached out to me. She's in Elko. She asked me to make representations that she anticipates being ready
Okay.
for the current trial date and would ask that her presence be waived for this particular proceeding.
Okay. Mr. Horvath, anything, are you guys on track as well?
Yes, Your Honor.
Okay. Staying on track?
Yes, Judge.
Okay. Status check at 90.
Be April 9th at 9 a.m.
All right. Thank you, guys. Ms. Rodolph, have you had any contact with Ms. Levy?
No, Your Honor.
Mr. Roush, I need you to use your inside voice. Ms. Rodolph, are you ready on field?
I have not heard back from Mr. O'Brien yet, Your Honor, so I think at this point it might be wise to just pass it.
Well, I mean, I'll see if we hear back from him by the time we finish the calendar.
Okay.
All right, are you ready on Smith?
Sure, yeah.
All right, let's go to page 10 and 11. C, 389651, State of Nevada versus DeAndre Smith. State of Nevada versus Ilana Siniceros. Make the record reflect that Mr. Smith is present in custody. Mr. Gaston and Ms. Rodolph are here on his behalf. Ms. Siniceros is present at liberty. Ms. Levy is here on her behalf. Ms. Gamero is here on behalf of the state. This is the date I set for a pre-trial conference, but there was also a motion to continue that was filed by Ms. Lee. It's not set until the 15th. You guys want to wait till the 15th to do that, or you prefer to go forward today?
Prepare to go forward today.
On the motion, okay. What is your position regarding the motion in regards to Mr. Smith?
We oppose.
Okay.
The trial date is set. The case is almost a year old. I read the co-defendant's motion. It's a generic motion to continue. It says they need time for investigation, preparation, and to review discovery. Their client's out of custody, confessed to the murder, said that they did it alone. The motion to continue is devoid of any specifics. It doesn't say what investigation they need to do. It doesn't have any mention of what discovery they just received, or when they received it, or why they don't have time to review it by trial. It doesn't talk about what preparations need to do. Their case seems relatively simple. It doesn't explain any due diligence that was done in the last 8 months as to why they couldn't have been ready for this trial date. It just mentions that their client's out of custody, so of course has no problem continuing their trial. Well, my client is not out of custody. My client's been in custody this entire time and wants his trial date. There's very little evidence tying him to the homicide. He wants to go to trial. So I'm objecting to their motion to continue. If the court is going to grant their continuance, I would ask for a quick reset. And also, there's a Nevada Court of Appeals case, I think it's called Chittenden, which talked about how courts are to consider a defendant's custody status when granting or not granting a motion to continue. My client's been in custody this whole time. I think when he was originally charged, he had a parole hold, so his bail was never actually addressed. So he's never had a bail set. So if you are going to grant the continuance, we definitely want to address the client's custody status, my client's custody status, so that he has a chance to get out of custody as well. It just seems, off the top of my head, a little silly that the co-defendant who confessed to the murder and said that they did it alone has been out of custody this whole time, and my client, who has very little evidence tying to him, has been in jail this entire time. So we either want to go to trial on the date that is currently set and contest the charges, or if it's getting continued, we want his custody status to be set in something that actually gives him a chance to get out of custody.
Well, I mean, Mr. Gusson, I understand the point you made, but I want you to know I'm not sua sponte considering anybody's custody, so that issue has never been raised with this court, so it's never been considered in regards to your client.
I understand.
All right, Ms. Levy, anything you want to add to
Well, Your Honor, and I haven't been on this case for 8 months. Yeah, so I was appointed right before the last trial setting. I was continued till this setting, which I said I don't believe that's going to be enough time. It was like 3 months or so for me to get ready over the holidays. There's absolutely no way I would be ready, and I told the court when it was set that I wouldn't be ready for this trial setting. I didn't receive discovery until after that, which is a large amount of discovery, multiple cell phone dumps, and I haven't had a chance to review everything. So there's absolutely no way I would prepare to go forward. Additionally, as this court is aware, I know the co-defendant's counsel is asking for a short set. This court knows that I start a 3-month federal trial on March 23rd in front of Judge Navarro.
On what day?
March 23rd.
Okay.
So I will not be ready to go before then. I'll be preparing for that. That's a 3-month, 11 homicide case in federal court. So I'd ask the court to continue. I mean, I'm obviously not going to be ready. So.
Okay. Ms. Camaro, what's the state's position on the motion?
I have no opposition, and just in Ms. Levy's defense, there is quite a bit of discovery in this case, so I'm not surprised by her motion at all.
Okay. Well, I mean, Ms. Levy did indicate, and Ms. Jackson, I know that you were not on this case at that time either, so you weren't here. Ms. Levy did indicate to us when this was set that she could not be ready to go. This date was likely not viable, but she would be working to get ready, as well as if the discovery she doesn't have, she doesn't know what it is that she doesn't have, as well as you guys have indicated in the motions and everything you filed, there were still things coming in and there were things that were being filed. I know I still owe you a decision on the motion to suppress because these things happened in the last batch of discovery and you filed the motion as quick as you could. So I understand where everyone's coming from. I'm going to grant the motion to continue over your objection. The January 15th date for the motion to continue and the calendar call will be vacated. The jury trial will be vacated, but I do understand where the defense Mr. Smith is coming from. And based on the several motions that Mr. Dostad has filed in this case, I'm aware of the facts of this case. So I believe that I understand where you're coming from in regards to wanting to consider your client's custody status. However, pursuant to the court rules, you have to do that in writing. And as I stated, this court has never been asked to consider your client's custody status, so I never considered it. You guys can file a motion, but what I am going to do is set this on for a status check because what we do with the trial date will determine what I do with the motion on your client's custody status. So do you think you can get it filed in a week?
We can file it by the end of the day, probably.
Okay, so you want to set it next, or do you guys want to, I can set it next Wednesday for you guys at 8:30, or I can set it, but it has to be at 8:30 because I have a civil calendar now, or I can set it next Thursday at 9.
Either day.
Either day, whatever works for the court.
Okay, let's Set it next Thursday at 9 to make sure everybody's here. January 15th at 9, and it'll be set a status check trial setting in regards to the and the status check trial and bail motion in regards to Mr. Smith.
The only thing to just bring up, so we've been requesting, so there's a lot of cell phone stuff and location data and stuff like that. We've retained an expert to kind of independently review and verify sort of the things at the state. In doing this site mapping, indicated that the list, the primer, you can only get that really from the Mr. a couple different times. I think the DA, no problem. That for us, she's rejected a couple times. But my understanding, back to her cell site list primer that are so having this kind of discovery issue and court order provided.
Well, I got an order provided is I'm going to ask Ms. Camaro to reach out, and if you think the court needs to intervene in getting that for you, then the court will intervene.
Understood, and I will represent that he recently, within the last few days, reached out to me. I just need to get on the phone with him.
Okay, so you reach out to him, and if that's an issue, then I'll intervene.
The only other discovery-related issue that Mr. Costa mentioned was we requested the complete DNA file. So there's a part of it, evidence in the case that allegedly has our client's DNA on it. We want the whole DNA file to be able to. We've reached out to the DA. I don't know if there's an issue getting that or not.
We just got it,
Perfect.
yesterday.
Okay, great.
So,
Okay,
send it over.
all right. And if there's something else, you guys can bring it up when we come back next week. Okay? And I promise you will have a decision by next week on the motion. I swear. I feel like, yeah, Judge, I heard that before. But I promise this time. So before I see you next week.
We know you've been busy, and
Yeah.
we've all been busy as well.
Thank you guys.
Thank you, Your Honor.
Let's go to page 15, C 391028, State Battle versus Salvador Delgadillo. Mr. Record, good morning. Mr. Delgadillo is present in custody. Ms. Jackson is not present. Ms. Fleck is also not present. This is their case together. They have been reaching out to my staff to reset the hearing in regards to the discovery motion, so we're going to continue this until that date. Okay? Because I'm pretty sure they thought this date was vacated, that's why they're not here. So this will be continued to March 5th.
9 a.m.
Thank you. Your Honor, the attorney for Fields is here.
Who?
For Fields.
Okay. Mr. Moore, have you had any contact with Mr. Becker's office on Rice?
I talked to Mr. Solinger, and he said he was expecting Mr. Goodwin to cover for him.
Okay, well, she's not in custody, so we can come back to her. Let's go to page 23. C 396529, State Nevada versus Levi Fields. May the record reflect that Mr. Fields is present in custody. Counsel, can we have your appearance for the record?
Of course, Your Honor. Shaylin Deere on behalf of Mr. Fields, bar number 16521.
All right, and Ms. Wilming is here on behalf of the state. This is the date time set for initial arraignment. Counsel, are you prepared to go forward with the arraignment?
Your Honor, we are.
All right, Mr. Fields, sir, what is your full name?
Levi Christopher Fields,
How old are you?
29,
How far did you go in school?
graduated high school.
Do you read, write, and understand the English language?
Yes.
Sir, are you currently under the influence of any drugs, medication, or alcoholic beverages at this time?
No.
Do you understand the proceedings that are happening here today?
Yes.
Sir, are you familiar with the 3 charges that you're facing?
Yes.
Do you understand those charges?
Yes.
After those charges, how do you plead? Guilty or not guilty?
Not guilty.
Sir, you have the right to have a jury trial set within 60 days. Would you like to invoke or waive that right?
Invoke.
Okay. This case is going to be assigned to Department 2. This case is going to have a status check trial setting in Department 2. That date is?
January 13th at 9 a.m.
All right. Thank you, guys. Any update, Mr. Ryan?
Yeah, she's on it.
Okay, as soon as she gets here, I'll to approach on an unrelated matter.
So are you,
All right, let's go on page 8, C 387854, State of Nevada versus Ricky Sanchez. May the record reflect that Mr. Sanchez is present in custody. Ms. Stanley and Mr. Gaston are here on his behalf. Mr. Albright is here on behalf of the state. This is the date and time set for sentencing. Are both parties prepared to go forward?
Yes, Your Honor. Yes, ma'am.
All right, state you had noticed 4 victim speakers. Do you have 4?
You also need an interpreter?
We only have 2 speakers out of 6.
Oh, okay. So like she had an interpreter during trial.
Please make sure your phones are off.
He just stepped out to get up and Bob on the phone. He was coming
I'll be right back, Mr. Jaskowitz.
That's really not my father.
at least. Ms. Michaels?
All right. Let's go on the record and see. 377-239, State of Nevada versus Devyn Michaels. May the record reflect that Ms. Michaels is present in custody. Mr. Draskovich and Mr. Horvath are here on her behalf. Mr. Giordani and Ms. Griffith are here on behalf of the state. This is the date and time set for sentencing. Are both parties prepared to go forward?
We are.
All right, just a couple housekeeping matters. State, the victim's mother sent a very long, detailed list of money she's out of, but I don't have any documentation.
I did
to
not
support.
receive that either.
Okay, so I'm going to award the $5,000 of restitution to victims of crime, but that'll be the only restitution because there was actually proof of that.
Understood.
Any objection from the defense to that?
No, Your Honor.
Okay, and we did have a discussion about credit, and we have the credit at 780 days. Is that correct?
That is correct.
Okay. State, you also noticed victim speakers. How many speakers do you have?
2.
And pursuant to statute, would you like them to speak last?
Please.
All right. State, since this is the result of a jury trial, you have retained the right to argue.
Yes, Judge, and you've been doing this as long as I have, if not longer. There's a couple of different types of defendants that come before you and that I've dealt with in my career. And there are those that don't function in society. They commit multiple crimes over and over. And then there are those like this defendant who functioned relatively normally for an extended period of time, but committed such an extreme act of evil when she did commit a crime that you have to put her on the far end of the spectrum of evil, Judge. I understand that her lack of criminal history is something that you're going to take into consideration when you determine whether she gets life without her or not. I really just have a question for the court, and I'm not going to try to provide an answer. And the question is this, is a person who is capable of such extreme evil, is that person someone that we want to walk our streets, whether it's 20 years from now, 28 years from now, or not? And you're in the row, you're on the bench, you get to make that decision today. I would just urge you to think about what it must have taken for her to do what she did. Not everyone is capable of that extreme amount of violence. Not everyone, not even some of our worst offenders go that far. There was some statements made at our last sentencing that I would ask you to take it in context with the evidence you heard at the trial. There is absolutely overwhelming evidence of her guilt, and obviously we have a jury verdict at this point. So all that nonsense that was spewed at the last hearing, I think that has been disproven during the course of the trial, and as evidenced by the very quick verdict that was delivered in this case. If you'll recall, it was just a couple of hours on the same day of closing arguments. With that said, Judge, I will submit it to your discretion, just defer to the victims.
Okay. Ms. Michaels, what, if anything, would you like to say before I pronounce sentence against you?
At this point, I just feel that anything I say, it won't. The family's looking for certain things, and I cannot deliver what the family's looking for. And they're here, and I just want them to get their, at least part of their anger out. I know no matter what I say, they're still going to feel the same way. So just let them have their time, and that's all I can say.
Thank you. Defendant?
Your Honor, I like to state I'm going to be somewhat brief. This was the result of a 2-week jury trial. I do appreciate Ms. Michaels' statements and even the lack of her statements. This case has had a bit of a wild ride to get where we are before Your Honor today. You know, the jury, and we all spoke to the jury afterwards, looked at basically one thing, and that was her statement to the police on August 15th. And she has made several statements leading up to this point, and today she's chosen to just basically let the record speak for itself and then the history of this case speak for itself. You know, Your Honor is in a very unique position, being basically a murder trial judge. The thing that I would like the court to take into consideration is the issue of proportionality. You know, you hear on a regular basis cases that involve years, if not decades, of criminal conduct. People that have substantial criminal histories. People that have committed crimes over and over and over again. Ms. Michaels has a gross misdemeanor conviction that was close in time to this case, relatively speaking. She, outside of the events that gave rise to this case, she's lived a very good life, and I think the court should take that into consideration in reference to this issue of proportionality and treating similar defendants similarly and different defendants differently. I mean, when we look at the object or the goals behind sentencing, we have deterrence, you know, we have incapacitation, we have rehabilitation, and then we get to this issue of retribution. And you know, the flip side of retribution is redemption. You have a woman that stands before you today who's 47 years old. She turns 48 in April. You've got a woman that was a devoted mother. She had a career. Obviously, what occurred is not going to bring Mr. Willette back. Ms. Michaels' case, if we take the version of events that the state presented, we have here, you know, you talk about stabbings and crimes of passion and things like that. You know, in this case, we don't have someone that's been charged with lying in wait, planning. We don't have a case where we have a life insurance policy that was viewed. You know, we don't have this, and when we talk about evil, I mean, that's kind of a slippery word sometimes. But at worst, what we have here is a conviction based on impulse and then perhaps bad actions that occurred following that. I mean, Your Honor spoke with the jury, we heard the testimony. We had this, and she was charged murder with use. And if we take the evidence in the light most favorable to the state, we have something where there have been unwanted sexual advances. There was a candlestick or perhaps a poker that was then used to strike Mr. Willette. And I'm using his name. I mean, the decedent, you know, I don't want to minimize, he was a person, obviously, as is Ms. Michaels. We have, again, we have an appeal that's going to follow, but nonetheless, if we take the version of events that the state would have the court take into consideration, we have an act that was based on impulsiveness and then bad, impulsive decisions that very well may have followed. You know, Your Honor, and one case comes to mind, I believe it's the Randolph Thomas case. We have a case where there's multiple former spouses, multiple acts. In this case, we have a single act. You know, we don't have this course of conduct that encompassed days, years, or in that case, decades. We have a single act that's now before Your Honor. You know, the very minimum sentence per statute that Ms. Michaels could receive is a 21-year sentence. We're talking 60 years old. And Your Honor knows the studies. I mean, like I said, you're in a very unique position based upon your experience and the depth, not only off the bench prior to your having assumed the bench, but as a murder trial judge. This is a case where the court should look at redemption. She can contribute to the community. She's had no issues whatsoever while incarcerated. In the beginning of this hearing, Your Honor addressed the credit for time served. She's been in for some time. I would urge the court to view, you know, to look at the facts and circumstances and the very difficult decision Your Honor has to make with the idea of redemption in mind. I would urge the court to give her as far as the murder charge, the chance at redemption, the chance to be perhaps one day reincorporated into society. I would urge the court to give her a sentence of 20 with the possibility of parole, and then the minimum sentence for the with use in enhancement. I would submit that this idea of proportionality and true equity and fairness would be served by such a sentence, and that's what we request, and on that I submit it, Your Honor.
Okay, thank you. State your first speaker.
You do solemnly swear the testimony you are about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God. Please state your full name, spelling your first and last name for the record.
Valeria Willette, Valeria Willette.
And ma'am, what would you like to say to me today?
First of all, thank you for giving me the opportunity to speak out. It's been a while, and I'm very thankful. And whatever I'm going to read is what I lived for almost 3 years.
Okay.
Excuse me. The brutal murder that took place on August 7th, 2023 has forever changed my life, my husband's, and my children's life. I am still in shock and traumatized because of this unbelievable act from someone who is selfish and heartless. About a week after Johnathan's murder, we came across a huge responsibility of taking in 2 young girls who we didn't know, and due to the circumstances, we couldn't say no when all others say they couldn't. My life has changed since the notification of my stepson's death. With us taking in 2 girls with us taking 2 girls in our home and getting to know them and not knowing of all the trauma they previously had, after the murder, even more trauma was added. It has been a tough 2.5 years for all my family. Grieving has been hard at home, since there were times when I needed to break down and cry, but I couldn't because we had 2 girls who depended on our strength. Along came caseworkers, CASA, Boys Towns, and CAP attorneys who visit our home several times a month. This doesn't include the process of getting fingerprinted, classes to be able to assist the girls while with us, and therapy for them and myself, husband on a weekly basis. The girls did not have discipline, boundaries, basic cleanliness, social skills, and proper hygiene. The clothing they brought from Child Haven was unfit for anything except playtime. I contacted their stepfather/brother, Davier, to see if we could pick up more clothing, and those were not much better. We ended up spending a lot so they could look presentable when in school and out in the community with us. We also have to deal with Casey, our daughter, who was in senior year and fell into depression, making it hard for her to be in school and caused a lot of absences. It was a huge change in her life, having to deal with 2 young girls with so much trauma and Casey graduated in June of 2024. It has been very hard on us since no other relative has assisted us in caring for the girls, only my immediate family members, which are my adult children. We have now built a relationship with Aunt Kayla, the killer's sister. She stopped by while she was in Las Vegas on business, and we had a great conversation, and she departed as a supportive aunt. Because of this meeting, the girls have changed their minds of what kind of person she is. We will continue to nurture this relationship with Aunt Kayla and the girls. Through Johnathan, we have gained a true friend who has supported us, especially me. We grieve together, and Bernadette has also lost a best friend. We talk, cry, and express our sorrows about how a person was taken away so brutally. We cannot bring Johnathan back. God has gained an angel in heaven. We believe he is watching over us and the girls. I ask today for justice for our family, especially the girls, because we have been sentenced for life with this tragedy. This will follow them for the rest of their life. We've created a time capsule for them in therapy where they can place notes or items that they can open in the future to remember their journey. We will never again hear his voice, his laughter, or see his expression. Johnathan doesn't have a second chance. His life has been taken, never to return to us. The girls have been left without a dad, stepfather, brother who doesn't make contact with them, and a mother who's in jail. After my marriage of 14 years, I have come to know Johnathan. Although we didn't have a close relationship with him, I miss his jokes, laughter, and him being funny. He would come around on holidays and enjoy our time spent with him. Thank you for allowing me to speak about the situation, and I am seeking the hardest penalty in this case. The killer that ended Johnathan's life needs to be put away forever. Thank you.
Thank you very much, ma'am, and thank you for being here today.
You do solemnly swear the testimony you are about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your full name, spelling your first and last name for the record.
James Willette, James Willette.
And sir, what would you like to say to me today?
I have a prepared statement
Okay.
that I would like to have you listen to.
Okay, whenever you're ready.
May I have a seat?
Sure.
Your Honor, I must apologize as I'm uncertain of the appropriate name to use. Tracy Reed, Tracy Tavares, Tracy Baker, Devyn Michaels, Nikki Fairchild. But for clarity in this context, I will refer to her as the killer and murderer of my son Johnathan. This horrendous murder crime has affected her two precious children, myself, my wife and my children in the household, my wife's mother, my wife's brother and sisters and their families, my ex-wife and her boyfriend, my remaining son, my grandson who married her, his mother and family, her parents along with her sister's family, and anyone who knows us or were friends with Johnathan. We have all been given a life sentence by a woman who doesn't respect life. She has removed from our lives my son, her daughter's father, her daughter's stepbrother, and all related individuals that were just mentioned. The enduring loss of opportunities to communicate with Johnathan, witness his achievements, and provide guidance is permanent. This absence is not limited to life without parole. It is not replaceable. Each day serves as a reminder of this lasting impact which will persist indefinitely. Regardless of the duration of her sentence, we continue to experience an ongoing sense of loss that will endure throughout our lifetimes. Our circumstances remain unchanged, and correspondingly, there should be no alteration to hers. As we grapple with the magnitude of what has been lost, we find ourselves thrust into unfamiliar roles and responsibilities, forced to adapt and preserve in the face of relentless adversity. The routines we once knew have vanished.
replaced by an ongoing quest to provide love, safety, and guidance for young lives so suddenly uprooted. Our whole household has become a place of both deep sorrow and determined resilience as we navigate the labyrinth of legal proceedings, therapy appointments, and daily challenges that arise from the tragedy of this scale. The weight of grief is compounded by the necessity to advocate fiercely for our grandchildren, ensuring their emotional and physical needs are met, even as we contend with our own sense of devastation. Despite the overwhelming nature of these circumstances, we are steadfast in our pursuit of healing and justice, propelled by a profound sense of duty to honor Johnathan's memory and to safeguard the well-being of those he cherished most. The tragic passing of my son, Johnathan, has had a profound impact on many individuals, including his two beloved children, his mother, our family, all relatives, the killer's parents and sister, as well as friends and acquaintances of his. We have all received an extreme life sentence, not a 15-year to life term. We have no parole. We just the knowledge and the heartbreak of his loss. Life has taken away my son, her daughter's father, her daughter's stepbrother, who is also her husband, and all others mentioned. The opportunity to communicate with my son, appreciate his life, witness his achievements, and provide support through advice is permanently lost. Every day we are reminded of this irreversible consequence. Nothing will change in 15 years, 20 years, or even our lives. Regardless of any duration served by the killer, Johnathan will not be returned to us. His actions are permanently ceased, and his voice will remain silenced forever. We are enduring a lifelong impact until the end of our days. This situation remains unchanged for us and thus should remain equally unaltered for the killer. We are consistently reminded of the serious impact of the killer's action on her life. Each day, the killer's daughters wake up to the reality that their father is no longer part of their lives, preventing them from sharing any experiences or creating memories with him. They experience significant long-term effects due to growing up without parental support, relying on grandparents, relatives, and others for assistance during a limited period before achieving independence. We are optimistic that they will understand they are not responsible for these circumstances and their future choices will help them avoid entering this system. Despite this, they will carry the burden of their mother's actions, knowing she has effectively removed both parents from their lives. These events have left two young lives facing significant challenges in their futures following the loss of their father due to her mother's actions. The recent events have been particularly traumatic for our family, especially for the children. My wife and I have attended classes to assist in raising our granddaughters and addressing their trauma. We are supported by caseworkers, cap attorney, CASA worker, Boys Town worker, therapist, special school classes, coaches, and the daily challenges resulting from the loss of both parents. This situation has impacted everyone involved. We have observed changes in attitudes of our relatives and friends due to this event. Both my wife and I have consulted a therapist for support, which has been beneficial, though the issue remains prominent in our lives every day. We have attended numerous court dates related to both the murder trial and the cases involving the child abuse and termination of parental rights. The significant time spent traveling, communicating with district attorneys, and enduring the anticipation of trial outcomes has severely impacted our mental health and well-being. Such experiences are immensely challenging, particularly when one child is tragically taken by murder, as Johnathan has. As a retiree, I anticipated enjoying my golden years, but now my wife and I find ourselves responsible for raising preteens once again. It is essential to emphasize that while we deeply care for the girls and are concerned about their future, proper medical care and dedicated personnel can help ensure they lead normal lives. We are making notable progress with Janaea, who is determined to improve her life and situation. Despite holding 3 licenses, foster kinship, relative foster home advanced foster care, and professional caregiver pre-service training, we continue to enhance our understanding of the trauma experienced by our granddaughters. These children have never experienced loving discipline nor had real interaction with others, as they were homeschooled rather than attending school. Consequently, there is a significant lack of etiquette in social environments and personal interactions with peers and friends. This is especially difficult for us in a family setting or gatherings on special occasions. Throughout this difficult and painful experience, our resilience has been tested beyond measure as we navigate the complexities of the judicial system and endeavor to provide a stable environment for our granddaughters amid relentless adversity. The emotional and practical burdens we bear have transformed our daily existence, challenging us to find strength in one another and in support systems available to us. Despite the constant reminders of the loss and the enduring pain etched in every aspect of our lives, we strive to foster hope for the future of our grandchildren, advocating for their safety, well-being, and justice in the wake of such irreparable harm. We have faced countless obstacles in our efforts to piece together a sense of normalcy, persistently navigating bureaucratic hurdles and emotional turmoil while every aspect of our daily existence has been altered. Every future plan reshaped by consequences of a single unforgivable act. The weight of responsibility continues to rest heavily upon us as we advocate for justice and stability, not only for our own heart, but for most importantly, for Jonathan's children whose futures have been so deeply scarred. We are requesting, per Marcy's law, the Senate Joint Resolution SJR Section 1, letter G, to reasonably notice of all public proceedings, including delinquency proceedings, upon request at which the defendant and the prosecutor are entitled to be present, and all parole or other post-conviction release proceedings, and to be present for all of these proceedings. Section N, to be informed of all post-conviction proceedings, to participate and provide information to the parole authority, to be considered before the parole of the offender, and to be notified upon request of the parole or other release of the offender. Section P, to have all monetary payments, money, and property collected from any person who has been ordered to make restitution to be first applied to payment to pay the amounts ordered as a restitution of the victim. As we move forward, it remains imperative that the lifelong consequences endured by our family, and especially our grandchildren, who will endure this crime for many years, are gone, are met with unwavering commitment to accountability and truth. The emotional scars, the logistic obstacles, and the persistent sense of emptiness cannot be erased. But through steadfast support and continued vigilance, we hope to honor Jonathan's memory and instill a sense of security and justice for his daughters. We deeply care for our grandchildren and find it challenging to come to terms with the actions taken by their mother, both regarding our lives and more significantly those of her children. The impact of this trauma may have lasting life on them. For instance, there is uncertainty who will accompany them during important events such as walking them down the aisle, at their weddings, graduations, birthdays, etc. There are moments in life when one must pause to reflect on one's circumstances. We examine all the known facts and attempt to understand them. The court hearings related to both the termination of parental rights and the criminal case. This planned and calculated murder, and remind it was planned and calculated, is not justified in any way or manner, and the killer needs to be incarcerated for the rest of her life. We respectfully request that the maximum penalty behind bars without parole be imposed for this heinous crime. We consider the act of killing and decapitating the father of the killer's children and husband to be egregious and extremely severe and should be met with extremely severe punishment. We trust in the wisdom of the court to recognize the full impact of these actions on all parties involved and to deliver a resolution that both acknowledges the depth of our loss and upholds the principles of justice upon which our faith now rests. Thank you for providing me the opportunity to share my perspective on this criminal murder. I now defer to your judgment on this murder case.
Thank you, sir, and thank you very much for being here today. Well, I think when Mr. Draskovich said it's been quite a roller coaster that got everybody here, I think that's quite an understatement as to how we got here. But I did preside over this trial for 2 weeks, and I was able to hear all the evidence that was presented by the state, as well as I was the judge when this case was originally negotiated in a settlement conference, and then Ms. Michaels wanted to withdraw that plea and proceed to trial. And the jury has ruled, and we all have to respect the decision of the jury. But I have to say, and I think Mr. Willette said it best, and as well as so did his wife, because one of the biggest concerns that I think we should all have as we deal with this is the fact that these children are going to be left without either one of their parents. And it's not any fault of theirs, it's not anything that they played a part in, but as well as everything that they had endured up to this point. And now, Ms. Michaels, based on your actions, they are going to be left without either one of their parents. Pursuant to the jury's verdict, you're going to be adjudicated guilty of first-degree murder with use of a deadly weapon. In addition to the $25 administrative assessment fee, your DNA was taken in 2022, so it's waived. The $3 DNA assessment fee, you're going to be ordered to pay $5,000 in restitution to victims of crime. You're going to be sentenced to 240 months to life in the Nevada Department of Corrections. There's going to be a consecutive 96 to 240 months in the Nevada Department of Corrections for the deadly weapon enhancement, and as of today, you have 780 days credit for time served.
Thank you.
Thank you.
Mr. Draskovich, your office will be allowed to withdraw at this point. Mr. Brown, we are going to appoint you as appellate counsel so that you can file the notice of appeal. Yes, you can put it. Thank you, Evan. Yeah, I was going to talk about it.